All right, should the county be required to count my vote in California? All right, this is going to be an update on the trial that just went down today in San Jose. This is going to be against myself, against the county of Santa Clara County Registrar of Voters office. I talked about it in the past in a couple of other videos, which I'll post at the end here. What happened was that I went in to vote on election day, and they said I wasn't registered to vote. So they provided a provisional ballot. I filled out the provisional ballot, signed it, dropped it in at the actual county recorder's office, Santa Clara County. And there's a statute in the election codes that says that under the election code, if you vote by a provisional ballot, you have a right to bring an action within 30 days before the canvass is over. And it says in any judicial action, and it should take priority over all other actions, any judicial action, any court. So I brought what's called a 1085 writ. It was basically I want to compel the county recorder to come to court and show cause why they either counted my vote or they shouldn't have to. And that's 1085. It's a petition for writ of mandate. And inside a writ of mandate, it says all courts, all judicial actions. All judicial actions is the wording. And then it says all judicial actions under the election code should take priority over all judicial actions, and then all courts under 1085. So I go in, I filed in small claims. Small claims court. I go, you know what? This is the best court for me. I want to have a fast remedy, make it easy. I don't want any money. I just want a simple order to show cause on a writ. So we had a fun discussion today with the commissioner, and ultimately what happened was the Register of Voters showed up at court. Cool. I had a great witness observer. Catherine came in and sat with me and had a good time, going through everything. So he comes into court. Matt Mays of the Register of Voters office. He's the Register of Voters. And we sit down, and ultimately you go. After I filed the action, the county showed that they rejected my ballot because I wasn't registered. My complaint is about, look, it's not a valid reason to reject somebody's right to vote because they're not registered to vote. If you have a grounds that I'm not eligible to vote, fine, say it. I'm not eligible to vote. Why? But not registered to vote is not legal grounds, because they have an entire set of laws that says there's provisional ballot statute laws. It says if you're not registered or you can't find a registration for somebody, you can do a provisional ballot. So that's what I did. So by saying I'm not registered, they rejected my ballot because they claimed I wasn't registered, which I never claimed to be registered. So we go into court. He argues that. He says that I wasn't registered to vote, and therefore they don't have to count my ballot or open my envelope. So I said, all right, Judge. And on the jurisdictional issue, because the judge wanted, the Commissioner Copeland, she wanted to know about whether or not this court had jurisdiction. I said, well, is this a court? Is this a judicial court? Yeah. I said, okay. And you're a commissioner. And she's like, well, yeah. Well, how does a commissioner have jurisdiction over a judicial action? I'm like, well, if you don't have jurisdiction over a judicial action, then I'm not going to stipulate to the commissioner. Okay? Because under the Constitution, it says that stipulation is required for all temporary judges, any temporary judicial officers. She says, oh, no, I don't require a stipulation. I am actually a judicial officer as a commissioner. I said, okay, great. Then I don't need to do a non-stip because you are a judicial officer, and therefore this is a court. And the statute says all courts, all judicial actions. Therefore, she says, well, this is the first of its kind. It's definitely an unusual case. We've never seen one of these before. I said, okay, great. Well, ultimately, what's going to happen is that we're going to determine, she took the matter under submission, and we're going to find out here real soon, within the next 3 weeks, whether or not the court's going to whether the court has jurisdiction, in their opinion, to hear a writ of mandate in a small claims action. Statutes are very clear and explicit on that. All courts. What she was looking for, she was saying, well, show me where it says small claims court. I said, Judge, it says all courts, or Commissioner, says all courts. Is this a court? Yeah. I said, well, then, okay, it applies. Is this a judicial court? Is this a judicial? Yeah. All right. And it says all judicial actions. It doesn't have to say, well, it only applies in this type of court. And that's what she was looking for in the statute. I was like, look, all courts, all judicial actions applies. That's explicit in the statute. Therefore, this court has jurisdiction to hear a writ of mandate, and it takes priority over all of other actions under the election code. So we had a good time talking about it. There wasn't any, I wasn't looking for any money damages. I was literally just looking for a determination on whether or not ultimately, I wanted to get a determination on whether or not how the court would handle a small claims action on a writ of mandate, for one. I want to also get a determination for getting the county Register of Voters to come in and answer, because they weren't responding to me. They were not communicating with me before I filed the action on it. So why they weren't counting my vote? What was going on? So I wanted to get them into court and to show cause, which they did. I have no gripes against the counties coming in and showing cause. They showed cause today as to why they believe they don't have to count my vote. They made their point. You want to know what they said? I checked the box that I'm not a resident or a U.S. citizen. Whoa. Boom. So then we argued the citizenship matter. I said, you really want to argue citizenship, Your Honor, Commissioner? Yeah, I want to argue the citizenship. I said, all right, let's do it. So I went into talking about the citizenship argument. And I said, well, fine. After 1940, the Washington, D.C., the House of Representatives, Congress, they passed a law called the Immigration and Nationality Act. This law, it took effect and basically created a new word inside the statutes, a new definition for what was previously known as a state citizen. Now, a state citizen was, under the 14th Amendment, there's two sets of citizenship. You've got federal citizenship, the U.S. citizen, and then you've got the state citizen, which is just a citizen of the state. All right? That's under the 14th Amendment. After the 1940 law, they changed the definition of state citizenship to what's called a national, not a U.S. citizen. Now, that is under the word just national, 8 U.S.C. 1101A21. It's statutized. Under the Immigration Nationality Act, it's called national, who owes a permanent allegiance to a small S state. Now, when I ordered the big, giant book, which I have in my office, I'll show it to you really quick. You don't think I'm crazy. Yeah, so in 1940, during Congress, they were using a dictionary, which was the giant Webster's, unabridged, in Congress to define the words they were writing within the law. So I went on eBay and I found the old dictionary, which is the size of a freaking house here, the 1940 version, all right? And in the 1940 version, unabridged Webster's, what's the word I'm going to look up? State, small s state. What did they mean under 8? What did they mean where they said a national is a person who owes a permanent allegiance to a state? Because this has been a debatable issue for 80 years since it's probably happened. People haven't, it's confusing. Well, I'm putting it to bed because when I look at the definition of state inside of the Webster's Dictionary in 1940, it says, a couple of, number 5, one of the commonwealths or bodies in which together make up the federal republic, which stand in certain specified relationships with an essential or national government as in regards to international affairs, are more or less independent. Each state's independent. Used especially of those which combine to form the United States of America. So lowercase s, small s state within the statute at the time of passing of that law meant one of the 50 independent states of the United States of America. Not a foreign state, not another country, one of the states. Therefore, a national, just a national who has a permanent allegiance to a state is a state citizen, okay? And therefore, that's what I explained to the judge today on the record. She didn't have a record in small claims, but ultimately and I asked her to make a finding. She wanted to go to citizenship, and I said after that, the cases in the Supreme Court stopped talking about state citizenship. They stopped going into state citizenship after 1940 because the new law came out. There's ultimately been, and that was what I had on the record. So when she says, so you're not a resident or a U.S. citizen, I said, absolutely not. Just like I put on there, I'm not a U.S. citizen. That's a federal citizen. My birth certificate says Californian. Well, I thought they got rid of that. Well, they tried to, but they just changed the definitions of it. Now it's under 8 USC 101A21. And under there's a right to where you can determine, I can determine, well, am I and there's plenty of laws that say, well, am I a federal citizen? Am I forced to have federal citizenship? Well, you're forced to have federal citizenship if we're in a serf society where we're all just serfs on the manor. We're all slaves. Okay, yeah, if that's the society we're living in. Otherwise, what the Supreme Court said is we have all the decision in the world to determine what our actual citizenship is. Is it state citizenship? Is it federal citizenship? Is it both? So I made a declaration on the record of that. And as a citizen of the state of California, a national, I have every right in the world to freaking vote. And that's what I had the court try to determine. I don't think they're going to go into all that, but what's exciting is they will go into most likely that they have jurisdiction to issue the writ. And I think it'll be a fun little ruling. And I definitely had fun. I appreciate Catherine going in there. They wouldn't let me film. They wouldn't let media requests come in there. But I did have, it was I thought, well-deserved interest because I had the actual Register of Voters in there, the acting Register of Voters. And we had it out, me and the commissioner, and had it on the record. He had a very simple, basic argument. So did I. And ultimately, I felt like they showed cause. We talked and shook hands outside. There was no argument. I wasn't upset. There's no emotions. It was really an exciting matter. They cleared the courtroom out. Of course, they made me go last out of everybody else. They ended all the other hearings before we had it. So it was a lot of fun. That's my update on trial against the County of Santa Clara Register of Voters on do they have to count a provisional ballot or not? What's their grounds? That's it. My name is Gavin. Hit the freaking ones. Leave a comment about what you think about this, man. See you at the top.